Hey guys, it's Anthony Bandiero here, joined by my good friend and fellow senior legal instructor for Blue to Gold Law Enforcement Training, John Wiehn. I am broadcasting from Dallas, Texas, where I have a class tomorrow with the state troopers. John, where are you at?
I am in beautiful Pasco, Washington.
Oh, look, we have some Washingtonians that are here today. So good. So look, and you're in Pasco. How's your class?
We're having a lot of fun. We did advanced search and seizure yesterday, advanced criminal investigations today, and tomorrow we're doing bulletproof report writing.
Good. One of my favorite topics. I think, and I know we're like blowing up in Washington, and a lot of it's because you're building up an incredible reputation over there. They love you to death. All right. So here's how this works. Okay. We are going to answer your questions live. For those who are watching us on demand, watching us on YouTube, John and I obviously are in our hotel rooms, unless we have a fetish about making our house look like hotel rooms. We're in our hotel rooms. We're going to answer questions, but here's the deal I have for you. If you come on and all you have to do has a microphone, cameras do not work. Okay, all you're going to do is see us. We know that we don't want to have your camera on, but what if you agree to ask a question? Then you get a challenge coin from Blue to Gold. Okay, we have the best challenge coins. At least we think they're pretty cool. We'll send you a challenge coin. All you have to do is answer a question. Now, um, all you have to say is me. I have a question and so forth. We'll turn on your mic with your permission. You ask your question. We'll answer it live online or live here, and then that's it. Rick will contact you with the challenge coin. Rick is going to keep a running tally of who is up on deck. We already have one person who has a question for John and I. All right. So here it comes. We're going to get down to business. I will also tell you the rules of engagement is that if you have a question that's written and you're not able or willing to come on the microphone, the problem is the people willing to come on microphone will always take priority because that's what people want to hear. They want to hear context and so forth. Um, John, why get Jim on here? So, John, I want to have a quick uh, disclaimer, not disclaimer, that's not the right word, but I want to, for these questions, I want to hit them as fast as possible and go to the next person, okay? Because we
Okay.
do have a lot of people that want to ask questions.
All
'Cause-
right. And you
and
know I like to give long-winded responses.
well, I think I'm a little more guilty of that than you, but regardless, maybe we're both guilty. What's up, Jim?
All right. Hey, good evening, guys. Uh,
Good evening.
so to set the scene, of course, we're in the wonderful state of Missouri, and for this instance, and so I had a suspect who get a warrant on him, uh, sitting in his house. He was evicted from this house. They went through the court process. The landlord gets possession of it and even gives them like 5 days after the date they get possession to move out. Unfortunately, my warrant comes the day after they move out. I go there, I meet the landlord, and the landlord says uh, that I'm allowed to go through the house, and uh, they said that there was a bunch of stuff inside, and they had spoken to the suspect who had been their tenant, and the tenant said the only thing they wanted was their car. Everything else, the landlord said he had a team coming to throw it away. So I treated that as abandoned property. I sat on this house for 23 hours doing surveillance, so I just went through everything in the house. And while I was there, I found uh, business records because this is a financial crimes case, business fraud. And so I took it, documented it, and seized it. And I'm just thinking, considering that now I had a verbal from the landlord, I know that there's a legal eviction. Was it right to treat that as abandoned property and just take it?
John, you want to take this or you want me to take it?
You take it.
So, Jim, so we have two things here, right? We have a legal eviction, correct? The person has been legally evicted,
Correct.
and they made comments to the landlord that they don't want their stuff anyway. That's inside the house. They just want their car, correct? So,
Correct.
all right, we're look, this is of course we got to be very careful. We're not giving legal advice, right? Because we're not your lawyer. We're both lawyers. John's a lawyer as well, but we don't want to come off as we're giving legal advice and get wrapped up in
Sure.
any kind of litigation and so forth. But the point is that based on what you told us, the law is absolutely in your favor. Number one is really once that eviction has occurred, they have lost their standing to be in that house, and if they've left their stuff in that house, well, you could have some. That's where statutory law comes in, where you could have an obligation by the landlord to, by law, maybe case law, but usually by law, to hold on to the property for a certain number of days to give them time to recover it. So that's like, so for example, in a similar example would be a storage unit. If you don't pay your storage unit and you're late, you don't immediately lose your stuff, right, Jim? You have like 30 days to come up with a payment and get your stuff. That could be an issue happening here, so I want to be careful about that. I don't know what the law is in Missouri, but the deal killer, really the death knell for this suspect is that they told another person that they don't want it anyway. You can use it as as abandonment, and they probably have no expectation of privacy anyway in the property. So either A, they're evicted and they just lost all their rights to the property. Most likely, your backup plan is they abandon it regardless.
Okay, thank you, gentlemen.
You're welcome. All right, who's next, Rick? Okay. Fred? What's the first name, Rick? Tran? You got to help me out here. Okay. A lot of people here, Rick, so I got to run through these. Okay, there we go.
Hey guys, do you hear me?
Loud and clear, buddy.
All right, question for you. Try to pull over a car for speeding. Hits the license sirens. He takes a couple of evasive maneuvers, but eventually stops about, I don't know, a couple blocks out, outside the norm of like a regular traffic stop. Approach the car. Passenger and the driver have a crossbody bag on the floorboard. They kind of like put their feet over the crossbody bag. So my question is, at that time and moment, justifying that, hey, they took a certain amount of time to pull over, and that these crossbody bags, my hunch is,
Notoriously for guns, right?
yeah,
The crossbody bag is the new fanny pack, right?
yeah. Would a Terry search of that crossbody bag at that time be reasonable or
So, yeah, and so it just may or may not help. But what state are you in?
California?
Okay, so look, California has great case law, but look. So first of all, I think you can appreciate that these are judgment calls, right? One judge, Judge Wiehn says we're good, and Judge Bandiero says we're bad, because they're judgment. It's what facts do you think are important and so forth. But if all you, I mean, are we talking about high crime area?
Yeah.
Okay, high crime area, delayed stop. You said delayed stop.
Yep.
How delayed?
Like 2 intersections and about a quarter mile off the freeway.
Oh, damn, that's a really delayed stop. I mean, would that be considered failure to yield?
Yeah, kind of, but in our
You didn't
state,
charge him, but probably legally it's failure to yield, right?
yeah.
So you got failure to yield. You have high crime area. Are you late? Is this late at night as well? Add to the facts.
Kind of like 8 or 9 p.m.
Okay, not too crazy. How many people in the car?
2.
And then the position of the bag. Do you think it's odd that the bag was on the floorboard, right?
Yeah, for the passenger and the driver.
They both have crossbody
Yep.
bags.
Yeah.
Were they twins?
And
So look,
they put their feet on them when they saw you looking at them.
Right.
okay. Oh, you right. You spotted them. They put their feet on them like as a reaction of you looking at them.
No, they kind of had already their feet over the bag, kind of like stomping on it.
Yep. Okay, good.
So that kind of just,
An apparent attempt to prevent you from detecting the bag.
yeah.
Okay, good. And then the final thing is, can you tell me anything about their behavior? Were they abnormally nervous? Were they,
Yeah, confrontational. The
Okay,
driver is
good.
definitely confrontational. So I
Challenging
took
to
that
stop?
factor.
challenging to stop? Is that just when you mean by confrontational? Like
Yeah.
you have the right to stop me?
Correct.
Okay, good. I call that legally combative. Maybe John uses a different phrase. I call it legally combative. Just you're trying to use the law to get out. You're trying to you just try to hassle the cop so the cop just like loses interest or
Yeah.
it's like this is not worth it. I don't get paid enough for this. But you're in California, so you do get paid enough for that. So I say the answer is yes. What do you think, John?
I'm good with it, and I think that this comes down to articulation, right? Because
Yeah.
when you first pitched it to us, you said slow to stop, and they had a bag, and I'm like, that ain't reasonable suspicion, right? They got
Mhm.
a bag. So what? Slow to stop. All right. Well, how long is slow to stop? But now you start talking about all these additional factors. You articulate what you are seeing, and that's what it comes down to: is totality of the circumstances. Is there a moderate chance to believe that these guys are armed and dangerous? Do we get anything on criminal history for them?
I think one guy just had a history of evading. Another guy had a bunch of narcs charges.
Okay. Yeah. So
Um,
you're definitely at an advantage because you're in California. California hates guns.
That's true. They do. They do. I mean, if you even think that there's a gun in there, which, look, but the fact that you know from your training experience, you can just probably call it your life experience,
Yeah.
that crossbody bags are really like the go-to holster for today's firearm is another factor. Somebody did say having the bag at your feet is suspicious. Maybe I think having your feet on the bag is. I mean, when I carry a crossbody bag with my gun in it, and I keep it, I keep it there. That's where I keep it. So I mean, but see, as your judge, I'd be like, it's because I'm a gun toter. I look at them like that itself is probably not suspicious because that's how I carry my gun when I'm driving around, right? I don't keep it on the seat.
Yeah.
But the point is that you have to be careful with that because it's still a factor. It's it's grabbable, it's semi-concealed. But look, I think you're good. All you need is a moderate chance of armed and dangerous. I think you did a good job articulating it, at least when we flush out those facts.
Fantastic. Thanks, guys. Appreciate it.
I appreciate you. Rick, do you see my text message to you? Let me see. Okay. 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 Who's next? Jason. Okay.
I am going to take a second, Anthony, and plug our advanced interdiction case law class.
Please do.
If you guys are looking for stuff like what we just talked about, take our advanced interdiction case law class. It's an 8-hour class. And for those of you guys who have experienced our Drugs on Wheels book, basically we took that 700-page book and we made it into an 8-hour class. Really, it's a 16-hour class. We have that too. But yeah, if you guys get a chance, advanced interdiction case law or our fully loaded interdiction case law class.
Yeah, we haven't dialed in the name yet, but really it's going to be a case law class. But this is a little sample of the book. It really is. I mean, for $50, you guys are getting there is no book like this, right, John? I mean, nothing even close. This book has been around for a while. It was always a good foundation, but John, I went through it one time, updated it, but it was not good enough. John went through it again and completely overhauled this book, and it is the best interdiction book on the market, hands down, without question. I'll put this in the link below. But buy the book and take the class. Actually, take the class and you get the book for free.
Ooh,
I think.
that's a deal at twice the price.
Yep. Yep. Okay. And sorry, miss, put this in here real quick, everyone. Okay. Okay, Rick, remind me who's next. Are they really? You think so? You see, we have a private message that we need to verify that. All right. Somebody says that somebody out there may be stealing our stuff. All right. And hey, Jason,
Hello, can you hear me all right?
loud and clear.
All right. My question is regarding the use of red and blue lights and white lights when it comes to detention,
Yep.
not just vehicles, but people. Had a couple of cases where the judge ruled that the use of white light constituted a detention, and throughout the case, I was under the impression, and that's why I was looking for case law. I was
Yep.
under the impression that the white lights basically was like shining sunlight on the car so I could see.
Mhm.
The other one is the red and blues. They just changed our light pattern not too long ago where we have red and blues even in our stage ones shining up front.
Mm.
And I was told that that is considered a detention even though they're not blinking.
What state are you in?
Colorado.
Yeah, look, I definitely have some feedback on this. But can you take it first? I'm trying to find some case law on the white light issue.
Yeah, and I got some too if we need it. I'll delve in and get Colorado. But Colorado, right? So we know about Colorado. We know about the 10th Circuit. Okay, they're going to be very restrictive. There is a whole lot of case law out there that says, white light alone is not a seizure, right? And there's
Right.
also a whole lot of case law out there that says red and blues alone is not a per se detention. Even in some of our more restrictive states, it says it's not a per se detention. However, is it a big indication of a seizure? And are a lot of people going to say an objectively reasonable person would not feel free to disregard you and go about their business if you're throwing on the red and the blues? And so my recommendation is if you are trying to initiate a consensual contact and you're going to use your overheads, I mean, the situation that you described where they're changing up your lights, I mean, that sounds like an issue, right? So for
Right.
me, what I would do if I was trying to initiate a consensual encounter is I would throw on my rear decks and then I would walk up on the person or the vehicle and I would say, "Hey, how's it going?" Right? In a conversational tone, introduce myself and be like, "Don't worry about the lights. I just turned those on so I don't get rear-ended and get myself run over." Right?
Yeah.
And so I'm getting out ahead of it. I'm taking that proactive step to be like, "Hey, sorry, don't worry about the lights." I mean, we all know law enforcement officers who have been rear-ended on traffic stops. Um, and some of us unfortunately know law enforcement officers who've been killed during that. And so is there a significant governmental interest in turning on those rear decks and letting oncoming motorists know our vehicle is stopped there? Absolutely.
Correct.
I can't find the case on white light. We do teach that, and maybe John can find it, but we do teach it. But look, it's almost I think it's almost impossible for a judge to say it is per se a seizure to use ambient lighting at night, and it's going to constitute a seizure because then you're going to get cops killed, right?
Right.
They're going to have blood in their hands. But also, can we also admit and just be kind of frank about it that you're damn close? Because I look at it this way: like John and I travel a lot. If I'm traveling, my flight's delayed, and I get off the airplane, I'm at a Taco Bell at 1:30 in the morning, not intoxicated, so I'm the exception, not the rule. And I'm in my car eating my Supreme. And look, the cop just wants to check on me. He's like, hey, he sees this guy in the parking lot, just want to make sure, A, I'm not drunk, or B, to make sure, whatever it is. And he comes up and he gets behind me, does not block me in, but puts on white forward-facing light. I got to tell you, Jason, I ain't going anywhere. I would never in a million years put that car in drive and start driving away. I would never take that risk because it's not worth it to me because I don't understand what's going on here, right? But
Right.
that's what John is saying is like when the cop comes up to me and says, hey, I'm just checking on you, making sure everything's okay. Boom. Now I know for sure it's a consensual encounter. So facts matter, context matters, but really when we do things that could be misunderstood, like the forward facing solid lights, red or blue, that can be misunderstood, right?
Right.
And John put the code in there, the case law, just balance it out. Like even if it was maybe it can come off as a detention initially, you put it right back to a consensual encounter. And one final thing, Jason, is that this happens a lot with broken down vehicles, right? A cop will put their forward facing red and blues on because they want to bounce the light off the buildings and make sure people slow down or on a curve. And it looks like a traffic stop, doesn't it?
Yeah.
Then the cop goes up there and says, hey, just check on you guys. You okay? You have a flat tire? Can I call you a tow truck? Boom. It puts it right back down to a community caretaking.
Okay. That makes sense.
Awesome.
Because in our area, we're in rural Colorado, so I mean it is dark. So that's why a lot of times we are using white light. Maybe
Yeah.
I'll talk to the guys about making sure that we're turning that into a consensual.
I think it's key. I teach as a pro tip. Just if you go up there and say first of all, my thing what I said when I was a trooper is if I use something like that, like either red and blues because of safety or the white light, I would tell the person almost the first thing in my mouth, hey, you're not in trouble. I just want to check on you. And then boom, can I also one more last thing? I just want to. Somebody talked about in California. In California, by law statute, it's a forward facing solid red light. I do think that I know that in culture matters. Obviously, in California, people know that solid red lights are the way you stop people. It's the same similar thing. Like I was in Georgia on Monday and Tuesday, and they roll around with what they call cruise lights. You've seen that before, Jason? It's kind of what
Yes.
you, yeah. Maybe that's what you guys. But they just cruise lights. People in Georgia, they don't think anything of it. It's just a cop doing his business. But there are some people out there that are visiting Georgia they start pulling over because they don't understand it. They're just not used to cruise lights. They see blue lights and they just think that that's how Georgia cops pull over people. My point is, culture matters too. So if you are in a place where you just have use your lights that way and people kind of know it, then that should play a part in whether or not it's a detention. Okay?
Okay, thank
Okay.
you.
Right. Okay. Okay, who's next, Rick? Okay, got it. And David, I don't see David right now. I see a David, but not that David. Okay, I don't see a Lopez here. Chris, who? Oh, I see Chris. Yep. Okay. Hey, Chris.
Hey, sir. Can you hear me okay?
Mm-hmm.
Okay. Thanks for everything. I'm in Texas. Just to give you a brief synopsis without going into much detail because it's still kind of active. Working off duty. Um, all I get is the original call of somebody pointing a gun at each other during a family disturbance. I'm working off duty, so they call me first before patrol isn't even called. Get there, briefly encounter the victim, briefly, but people are surrounding her, and all they do is point in a direction of the SP where I'm not even positive it's SP. I just point in a direction, not even at a direct person. So before they can leave the area, I go make contact with them, just to kind of talk to them. They don't argue the detention. They ask me what's going on. I tell them, and as soon as I ask the SP, who I think is SP, because I'm going, the only thing I have on this is gender. There's a male and a female. Asked the female if I can get consent to search a bag. Immediately, she looks to her friend, who's the only witness in the area, who says he's an attorney. Ask her if he can represent her. She says yes, and he says you won't talk to her no more. You're not searching anything, and they get legally, how do you say, defensive, the way you said earlier.
Yeah.
Right.
Yep.
At that point,
Combative, yeah. Mm-hmm.
yeah. So at that point, I'm trying to say, okay, how can I even argue if she's dangerous? She's not acting funny. She's not acting nervous. There's nothing. I don't even have a description of where the gun was put. I have nothing at this point. I'm waiting for backup. Once backup was get there, they were able to go talk to the victim, get more details on where the gun was put. And at that point, once we could articulate more stuff, we were able to go in there and do Terry stop of the bag and everything like that. The argument after the fact was, why didn't I get the bag immediately and do a Terry stop based off the circumstances I had already? I argued I didn't have enough. I couldn't really consider her dangerous. She wasn't acting funny. I couldn't articulate getting into the bag, so I just waited. And they weren't, like I said, they didn't argue the detention. They just argued the bag. Was I wrong in any of that part, or could I have gotten the bag sooner?
I may have not. I may be missing some pieces of this. John, did you follow along a little easier? Because
Oh, I think,
talker.
yeah, he is.
Sorry.
He is, and I appreciate that because we're trying to rapid fire here.
Yep.
I think there are more details to it, and we're trying not to be too specific because the situation is as of yet unresolved. And so ultimately, the question is this, right? You are the one who is going to have to articulate and justify armed and dangerous. Now, the Ninth Circuit has routinely recognized that armed equals dangerous when we're talking about a detention. Arizona, you have to get more specific and say it's armed and dangerous because everybody in Arizona has a gun, okay? Everybody in Texas has a gun. But it sounds like what you're talking about, we've got a lot of people there. We've got a kind of a tumultuous situation. It's tense, it's uncertain, it's rapidly evolving. And then, this lady's like, and this guy's my attorney. And he's like, put $1 in my pocket, right? And we're like, what in the hell is even going on here, right? So ultimately, I think if you have if you have reasonable suspicion to detain her, which you're telling me you did, there is a basis to believe that there was some crime occurring involving a firearm, right? Again, I'm making these deductions based on what we're saying. So you have reasonable suspicion to detain her. You have reasonable suspicion to believe she has a weapon. You have reasonable suspicion she's just, was or is about to be engaged in some kind of general criminal activity. It sounds like you have enough to frisk the bag. However, you are the one who is ultimately going to have to justify it and articulate it. Nobody else. And so that's going to be very hard to do if you, in your estimation, said, I don't think I have RS for armed and dangerous. Okay. Now, is that stemming from, a lack of experience or knowledge, or, recognizing all the factors. I don't know, but ultimately,
thought-
you're the one who's got to justify it.
Exactly. I figured once the cover got there, they can actually go talk to the victim, give me more information. Like, did you see what color was bag? Did you see her put it in the bag? Can you give me more details and give me more stuff to articulate in a report, such as bullet points, like we taught in the report writing. And if I can articulate that way, I figured I could just wait if I have time to wait, which I did. And everything turned out fine. But it was just Monday morning quarterbacking by everybody else. I figured I'd ask the question and see what y'all thought.
And Chris, we want you to be safe, man, right?
Yeah.
And so at the end of the day, if you have RS to detain this person, do you have RS to separate the bag from her?
Yes, and that was done. The separating bag from her was done. It's just searching the bag can we do it at this point?
Well, okay. And are we frisking the bag or are we searching the bag?
Searching the bag. That's what I didn't feel comfortable doing either one. I maybe manipulated a little bit, but definitely going inside, I was not going to do that until I had more information.
Okay. And I agree with that.
Yeah.
Okay.
Nice.
Thank you, gentlemen. I appreciate your time.
Manny, you're on deck.
Gentlemen, good evening.
Good evening.
How's it going? I'm here with my LT.
Oh, LT, can we talk privately? No, Manny, dude, Manny's is a longtime listener of the Search Seizure show. So what do we got? We got some other people that want to be on deck, but of course, we want to hear what story you got for us today.
All right, so I messaged Zach Miller already, so I already got our answer. We already squashed that part. Now this is the next part that we're like kind of confused on, and it's Georgia v. Randolph.
Okay.
Now here's the question. How do I word it? So I understand Georgia v. Randolph. One consenting party says yes, the other one says no. It's a no. That's okay. Somebody, not gonna say who, but they said that only has to deal with evidence, not people. So it stemmed from a domestic. Wife comes to the precinct. You got PC to arrest warrantlessly, no warrant, no nothing. You go to the house, and outside the window, he says, "No, stay out." Me personally, of course, gonna get a warrant. You gotta stay out.
Yep.
But what we got was, no, she's consenting. She's allowing you in. Georgia v. Randolph only has to deal with evidence, not people. So because you're not, quote, searching, you're just going to go get him. And I mean, I already know the answer, but if you could just clarify, like Georgia v. Randolph, like I think the Supreme Court in context was saying, yeah, we did talk about evidence in the case, but it's generalized. Like, hey, if someone says yes, husband says no, and a wife says yes, it's a no.
Well, but I think the better way to look at it is like how, look, of course, people. This is not the first time I've heard this argument, and people bring it's like, oh no, that's all about searching, of course. Okay, so let's make sure we're on straight. We're straight here. You can't search, but you can seize. It just that makes no sense to me. You're going into the home. The question is, are you lawfully present? If they said you were not lawfully present with the whole searching issue, how can you be lawfully present with the seizing issue? So, okay, what about this, Manny? Look, Your Honor, I don't want to search for evidence. I already know where it is. It's in the top drawer, of the right, or it's on top of the dresser. I'm not going to search for it. I just want to seize it. Do you think the court would uphold that?
No.
Of course not. It's ridiculous. There's no looking from the Supreme Court. They're not trying to send hey, we have a loophole here. Just seize, don't search. As long as you're not searching, you can do it. No, that's ridiculous. We don't teach that. We know what the answer is. John?
Yeah, Payton versus New York was very clear about this. Right?
Yeah, I agree.
Every opening into the home has a red barrier blocking it, and you don't pierce the red barrier absent consent, exigency, urgency, emergency, or a warrant. And in your scenario, the guy said, "Don't come in my house."
Right. I was just somebody saying, they're like, nope, Georgia v. Randolph is only about evidence. And I'm like, that doesn't make any sense because entering the home is still considered a search.
They do call it search. I personally look at it as a seizure because you're depossessing a person of their you're depossessing of their use of the home because you're standing in their living room and they don't want you there, so they cannot use their living room like they want to. So that's my issue with this. Like, even if it's not a search, like, I'm gonna stay in your living room, I'm not searching for anything, but I'm gonna stand right here. It's still a seizure under the Fourth Amendment, right? I mean, it still implicates the Fourth Amendment. If it didn't implicate the Fourth Amendment, then we would be able to tell cops that they can go into any home for domestic violence and don't need to argue exigency, right? Because you're not searching or seizing. You're not trying to search for evidence of the domestic. You're just trying to be there and listen, but it still implicates the Fourth Amendment. You right? You understand? Like, yeah. So the problem is that doesn't work. Okay, it's completely, quite frankly, I'm not trying to be rude here.
Say how it is, brother. Say how it
say
is.
it. Yeah,
It's a completely utter. It's not even really defensible. Okay, you're not going to win that, and you should not win that in a court. To say, as long as I don't search, I'm good all day. I can be in this house. That is ridiculous. Payton covers these issues. Randolph, the intent of Randolph covers these issues. You can look at other case law. And look, and I can just also tell you, John and I, and plus everybody else, have been studying this issue for decades. We have never, not once, found a case that says you can do what you just said.
Right.
Not once.
I agree. I just needed to hear from the
The master.
the master. Yeah, there. Let's just call it what it is.
Yeah.
The
From
horse's
from
mouth.
the crew.
Yep. Yep. All right.
Appreciate it.
I appreciate
Thank
you
you.
guys. All right. All right. Who is next? We got Matthew.
Yes, hi.
Hey, buddy.
Hey, I'm also from Texas. Actually, Tris Chato from the other day was a coworker of mine, or the other minute there. Anyway, it's
Nice.
a long-running argument now between me and a former supervisor. We found a cell phone during a traffic stop in a car. Nobody wanted to claim it was theirs. They argued that you could open up, yeah, it was password protected and everything, that you could open it up and do the medical information screen without a search warrant to see if it had anybody's ID on who it was.
Okay. And I'm sorry, just why are we doing this to the phone? Because the person is what?
They had drugs in the car, and they were trying to see if they were, they were trying to ID whose phone it was, I think, to seize it and put a search warrant on it. But they argued, hey, we can bring up the medical ID because it doesn't have to go past a password.
It's ridiculous.
And I was saying, no, that doesn't sound right. Let's just, get a phone dump on it later and all that. But they
Yeah.
wanted to say they could get the ID from that without a warrant and everything. And that's wrong, right?
No, it's wrong. So it is, and we're not saying, look, what we do at Blue to Gold, we say, hey, is it a search? Is it a seizure? And then you go with the acronym CREW. Do you have consent, a recommended exception, or a warrant, right? So here, I'm going to give you a case right here. So here's a case about just dialing 911 from the phone was a search to find out whose phone it was. So look, this is clearly a search. You are, especially with medical information, quite frankly, you're violating their privacy interests. They could have personal stuff in there about their medical condition. But more so, it's also a trespass. You are manipulating the phone to gather information. That is a search under the Fourth Amendment, without a question. And if you're doing it in order to get a search warrant, it shouldn't be done. You're going to have a good faith exception because you're going to end up, if you at the time of the search, the illegal search, you were going to get a warrant, you shouldn't lose anything. You shouldn't be penalized. There's debates on whether or not that's true, how you look at that, but it's not needed. You don't have to have that information to get a warrant. You describe the phone by its physical characteristics, and you get the warrant that way. Any follow up, John?
No, it sounded like we were trying to go for like an abandonment argument, which, you
Was
might,
that-
yeah.
Okay.
I think they were just lazy, to be honest.
Okay. Yeah, you might be able to make that argument, but it might be hard to do if we just arrested everybody in the car, right? And then we're like, hey, whose phone is this? Is this your phone? And he's like, screw you. And you're like, oh, okay, well, he said it wasn't his phone. But yeah, I don't know, Anthony. I see this a lot, and I get this question a lot, is people are like, I need to identify who owns the phone before I can apply for a search warrant.
That's right. We know that's
There were some other, they
Okay.
had more issues than just that, but
Yeah.
that was something that we've been arguing about for like a couple years now.
Okay.
And yeah.
Yeah, it's,
But
but we can agree though, right, Matt, that that's not needed. There is no requirement that you know who owns the container
Oh
before
yeah,
you
of course
search
not.
for it. Yeah, we do that with cars. I mean, sometimes a car will flee from us. I'm not saying, you might have the motor vehicle exception or abandonment, but when you get a warrant, you just describe the car by what it is. It's a car with the VIN number or the VIN, and we go from there. So no, that's not required, and we shouldn't manipulate the phone like that. It's not needed. It causes needless suppression hearings. Even if you win, it just slows us down. There's just no need to do that.
Yeah, that's what I figured. Okay, thank you.
You're awesome. Thank you. All right. Dominic, you're on deck. And Rick, who is next after Dominic? And Dominic, do you see the little button to unmute yourself? Should be coming up like a little dialog box. I think that's how it looks. All right. Who's next? And then Dominic, I can give you my cell phone number. You can call me and we can put you on speaker. Who's next, Rick? All right. Hopefully, Dominic, you can figure out your microphone while we get Mike on real quick.
Hey, can you guys hear me?
Hey, Mike.
Hey, so pretty simple scenario. I'm out in Texas. We had a armed security guard get involved in a traffic collision. He was transported to the hospital for his injuries, and he left his firearm in the vehicle. Our patrol officers obviously seized it for safekeeping, which I'm 100% good with.
Yep.
But our department has a thing. All cases go to CID, and so I get assigned a case. All I have is a safekeeping of a firearm. The guy calls me up, says, "Hey, I'm released from the hospital. I want to get my gun." I tell him, "All right, I'm going to run the CCH on you. As long as you're good, we're going to get you with our evidence check." I get notified by my sergeant that we are not going to be doing that. Apparently, there's an unwritten rule that our department has where all firearms, regardless of when or why they are seized, have to go to NIBIN. And
Yep.
then we have to wait a 90-day process after that to verify that there's no late hits. And this guy's calling me up every day demanding his firearm back, and rightfully so. And I just everything in my soul tells me that this is not right.
Not
And
right.
I was just kind of curious about that.
No, it's go ahead, John.
Anthony, there's a case that it kind of sounds like this. It's Caniglia versus something. You familiar?
Well, the only thing I worry about, I'm hesitant using that case because that was, obviously the home issue. But
Right. But he goes to the police department and he says, "Look, I'm not crazy. Give
yeah,
me the guns back." And they're like, "Nope."
yeah. Look, there's two issues here, right? First of all, this might be, I mean, not giving, look, it might be a civil issue, right? You're not giving back his property. I mean, do you not, if you take my backpack because I go to the hospital, I'm on my bicycle, and I get hit by a car, and you take my backpack and you put it in safekeeping, are you going to hold my backpack for 90 days? I mean, it's ridiculous. I mean, why can't I have my property back? The guy, he's a working man. He's slinging, he's a gunslinger for hire. Why can't he have his gun back? But the other issue, that whole 90-day thing is really going to be a civil issue. It's going to be, whatever it is, right? You might get an injunction to stop doing that. You don't get to arbitrarily keep people's property, whether it's a gun or it's a backpack for 90 days, right? Is that right, Mike? But the next thing is this NIBIN issue. There is a case out of Washington, where they said that the cops were allowed to do a NIBIN as a matter of routine on firearms because it's a part of the inventory procedure. I do not buy that at all. I think that's completely BS. The logic in they said that's no different than looking at a serial number because the NIBIN is a specific characteristic of the firearm, which of course it's like a fingerprint. But it's not needed. I mean, you don't do a forensic analysis on a vehicle when you tow it. You don't check the paint spectrum, right? So,
Correct.
look, I just think it's dishonest. I think it's a judge in Washington that wants to send somebody to prison for a gun crime, and they sleep better at night because they hate guns. That's what I think about that case. And I think it's a search under the Fourth Amendment and you're in Texas, you said, right?
Yes, sir.
So you can look at Richmond, right? USV Richmond, 20, what, 15? Probably. 2015 US v. Richmond Fifth Circuit. That's where they said that a Texas trooper poking on a tire to try to gather information was a search on the Fourth Amendment, right? Because he thought that there might be something in that tire and it ended up being a hidden compartment.
Mhm.
And so you're going to tell me that poking a tire in Texas is a search, but shooting a bullet down the rifle of this guy's personal own firearm is not a search because you're seeking information to put it in a national database to hopefully, tie that gun with an unsolved crime, which is noble. I mean, we want to solve these crimes, but you have to do it the right way. So what I teach is this. No, if I'm a legal advisor for an agency, no, we do not NIBIN guns that are in our inventory for lawful purposes. The guy was not committing a crime with the gun. He was not a prohibited person. The gun was not stolen. He did not even look, even with the guns. Let's say that the guy was intoxicated. What was this crime? He had an accident, right? Yeah, accident. Yeah.
Yeah, and it wasn't even at fault.
Yeah, it wasn't even fault. Like if he was drunk with a gun, I mean, that's look, I'm not looking to take that one to the mat. It's that issue right there. I will tell you that there was a case that I don't know if they played it out, but it was the case that was going to resolve this issue. It was, and I thought it was actually from Texas, but I'm maybe making that up. But all I know is that this guy randomly shot a homeless person in his tent. It was a random crime of violence. It was unsolved for over a year. Then this guy gets picked up at Walmart for shoplifting or something like that. He has a firearm on him. They take the firearm, of course. They knife in the gun. It comes back to ballistically to that unsolved murder from right. And I said to myself, there it is right there. That's going to be the issue. To me, if I was a defense attorney, the issue in that case. Did they have the lawful authority to knife in that gun as a matter of routine? Because remember, he was not picked up for murder. He was picked up for shoplifting, and the gun happened to be in his possession. He was not a prohibited person. The gun was not stolen, and I strongly believe that was unwarranted. It was a warrantless search or seizure without crew. John?
Yeah, I mean, I think that that's a significant infringement on one of our principally protected constitutional rights.
Yeah, and then and Corey does bring up the due process issue. I was kind of looking for that because I know holding people's property indefinitely or too long can actually either be a conversion, it could be a taking. Yeah, that's gonna be a little bit of a hard sell. It's not really. I don't think it's a taking, but it could be a due process issue. But that's above my pay grade. But I do think we have a search or seizure issue.
All right, thank you guys. I agree with you.
100%. And so one day we're gonna lose a murder case because of it. Okay. All right. Next, Rick, Dom V. Hopefully your mic works though, because I think we had an issue with the mic last time. All right, there we go.
Sorry about that, guys.
No problem.
So I'm out in California, in the Bay Area. Just some People v. Lopez from 2019 questions. When that case law was in the process, 2018, 2019, we were trained that, hey, you can no longer search in reasonable areas, the glove compartment, center console, the wallet, for registration, ID, a DL, or insurance. But however, it was brought to my attention super recently that apparently Lopez was possibly granted, but not granted. It's kind of like an awkward stage of
They probably gave the cop good faith because at the time of Lopez, it was permissible in California to look for credentials, look for IDs, right? So that might be there. But no, but Lopez, okay. So the question is Lopez still good law? Is that probably the question in California?
Yeah, I mean, obviously, based off some training experience, narcotics, guns are found in glove compartments. People don't want to give their license or registration because they know they have other illegal stuff on them, and they just want to kind of play hardball. But just kind of have that knowledge of Lopez now of, yeah, can we do it? Can we search for the ID? Can we search for the registration and insurance?
John, you want to take that or you want me to take it?
So, I mean, I never liked that about California, right? So California is not a stop and ID state. You are not a stop and ID state, right? And so there is in California limited authority for searching a person if you believe that they are being dishonest with you about their identity, and it's ugly and it's convoluted, right? So I'm saying don't rely on that. Instead, tell me what we're doing. Do you have PC for this person for false statement to law enforcement? Do you have PC for this person for lying to you about their identity? If you do, then arrest them and search them incident to custodial arrest. If you arrest them and they are in a vehicle or they're an occupant or recent occupant, and you arrest them for providing false statement or false information to law enforcement, under that rationale, do you have reason to believe that evidence of the offense of arrest is inside the vehicle? The answer is yes. So under the Thornton exception, as established by Arizona versus Gant, you can search that vehicle anywhere that could reasonably contain ID, registration, personally identifying information. But just this idea of like getting on somebody and I mean, it was almost like you could frisk them for ID. Is that correct, Anthony? Am I remembering that
Yeah,
case?
you can basically you can go through their car and get their credentials. It was mainly for Lopez was an ID case, of course, like a license. Um, you can look for credentials if it's like an accident, right? Like a auto accident and so forth, and they're like gone and they're transported. That's like almost like a crash investigation. But the point is, it was looking for this ID. When they didn't produce their ID, the California cops will go in there and look for the ID. Only
But there's other ways to ID people, right? You could do reg checks,
yeah, but you can
right?
do
Or
fingerprints.
whatever else ways of
The
identifying
fingerprint
besides
reader.
going through the cars.
Correct. Look, California, look, Lopez realized that California and New Jersey were the only states in the union that ever recognized this license exception or this credentials exception. And they realized that it was dumb. What you do is you just say, hey, do you have your license on you? No, then and you think they're lying about, then arrest them. You have other, like if they don't, in California, if they don't supply satisfactory ID, then can't you arrest them?
Yeah, we have CVCs and a PC for misinformation and
Yeah, I mean, you
all these
have
things.
tools. If you don't believe who they are, just take them to jail.
Yeah,
Okay, no, you're good.
that's
No,
it, guys. Thank you.
but Lopez, I think the issue with Lopez is that you're like, it was the law of the land at the time of Lopez. The cop did not mess up in Lopez. He was doing what he was told. But
He's
so
just in California.
in California, he was doing what he was told. So he gets a pass. You know what I'm saying? That's why you probably have cops looking at that case and say, well, the evidence still came in. It's because it was good faith. He didn't know that the law was unconstitutional. Is that so it's going forward, you can't do it. That's probably the issue there where other people are saying Lopez is not good law. I think.
Okay.
Okay, buddy. Hey Fred, what's up? Yep. Hey Fred, can you hear us? Hold on. And all right, Fred, do you see the okay, there you go. Your mic may not. Oh, do you want? Okay, look. I'll give you a phone number to call. Okay, is that cool? I'll give you a phone number. We can do it on speaker, but let's take a. Is that cool? All right. Don't forget, Rick. You see Dominic's message. All right. All right. Who's next on deck? And Frederick, I'm gonna give you my phone number, but just don't call it yet. Who's next on deck, Rick?
Benjamin Olson, Anthony.
Thank you. Hey, Ben.
Hey, can you guys hear me?
Yep.
Perfect. So I guess my question is about like recently when officers in my agency have been making traffic stops, I've noticed quite a few of them have been starting to show up like 3 to 4 at a time, even though if there's only like 1 or 2 occupants in a vehicle. When is too many officers like a bad thing where that might get challenged for like a seizure sort of thing?
It's bad when my taxpayer money is being wasted on 13 officers being on a traffic stop, and then the Uncle Sam says you owe this much in taxes, and I'm like, well, can you take it from somewhere else? That's the first place we start. What state are you in, Ben?
Wisconsin.
Well, okay, okay. I know we don't have this problem in the Dakotas. You can never have too many officers on the scene of Dakotas because there's not that many officers. All right, so. All right. Look, So I think the question is the so what part, right? They call us overconvergence or saturation. It can have PR issues, but we're not here for PR issues. We're not here for saturation issues. The reason why we bring up, and it can come up into a court case about having too many officers on scene, is because it can come into play when it comes to Miranda, whether Miranda is required or it's a de facto arrest. But generally speaking, if it's not, it's probably going to be a Miranda issue. That's why people bring this stuff up. But if it's not a Miranda issue, usually, then it's a decision by the department about what their policy is about how many cops can be on scene. So, do you have any? In other words, right? Do you have anything specific about what bad could happen legally by having too many cops on scene?
No, I think Miranda was what I was thinking with the issue would come into that is if all of a sudden there's 4 cops and there's, you
Yeah.
know, only 1 or 2 people, it's like, okay, well, at what point if we're going to continue this, do we need to Mirandize them?
Yeah, and it's also actually Matt brings up another point. It's also consent. This is also remember I made my joke about surrounding people, back on. That's another. So it's with consent. It's Miranda, de facto arrest. But yeah, that's when it comes up. But I mean, it is what it is. I mean, when you do have 2 people in the car and you have 4 cops, it doesn't look a little different when you're in LA versus Wisconsin, because in Wisconsin, everybody has their own car. And in LAPD, it's 2 to a car, so it's 2 cars. I mean, just saying that visually, it doesn't look as bad in LA. But
Okay.
in Wisconsin, looks like the guy probably fled the police and was shooting at you guys because you have 4 cop cars on scene. So the point is, it's PR and it's maybe a legal issue for Miranda, but you can, I have a class on interview and interrogation law where I talk about how to take the arrest out of detentions and so forth. All right. All right. So Fred, call me. Let's get you squared away. There. Oh man, Fred was not messing around. Fred was not messing around. All right.
Hey,
All right.
question for you.
Hold on. Let's make sure. Rick, are we good? Start speaking. I'm not even sure where my damn mic is on this laptop. How funny. Okay, we're good. We're good. Okay, go ahead and talk.
So last weekend, 2 cops go to a DV assault. The ex-boyfriend rents a room in the ex-girlfriend's house. 3rd-degree assault, cops go in there. Victim says, hey, there he is right there. He walks back in the house, shuts the door. They get consent from the homeowner to enter the house. Suspect retreats to the bedroom, pokes his head out and says, pound sand, get out of my house.
Mhm.
So the cops agree, they leave the house, and then they contact the victim again. And she tells them that she was choked, and they have probable cause because they didn't have that prior to. She gets transported to the hospital for a 2nd-degree assault, so got a felony. Can the cops go back in there and hold on the common areas outside where the suspect retreated? That's part one. The second part's actually the arrest, where we get into pursuit the following day.
So the question is, okay, so the victim, so at this point, the victim is gone at the hospital. We already know that he does not want us in there.
Mhm.
And we have PC for him for a felony.
Yes.
And she's cool with us going in there, but that's not the point. The point is that he's in there, does not want us in there. We know that's a valid lack of consent, and we want to go in there and arrest him.
Yes.
No. Because we don't have, with those facts and those facts alone, unless you have something else that I'm not aware of, you don't have any urgency or agency to go get him. That's Payton, right? Payton versus New York tells us that even if you have PC for a murder, you cannot go into their home to arrest them without a warrant or some level of urgency. Like he's going to destroy evidence, or he's going to escape, or he's going to, he's going to fire upon officers when you guys, you're going to give him time to, he's a dangerous person. He's going to fortify his position. He's going to try to hurt officers. I mean, you have to have something pressing. Do you have anything pressing here will something bad happen if you do not go and get him right now?
So she gets released from the hospital, and she's adamant about going back. It's her house.
Okay,
So we're like, well, we can't do that because now she's like, well, there's guns in there, and I'm afraid that he's going to arm himself. No problem. We're still not going to go back in there, but she's still adamant about it.
Okay, change the fact, change the answer. I think we are good now. Look, How look, I've spoken to DAs about this, and I've never found I found some cases that do support what I'm saying here. There's no like direct case that's really on the point. But look, does she have a right to be in that house?
Yes.
And does she have a right to also be free from injury?
Yes.
So why can't you so the Ninth Circuit actually called this a special needs doctrine, where it's just it's like you're in a rock and a hard place. Like you just have like it's a special needs situation. Like what if you do nothing, she gets hurt.
Exactly.
So I
let her go
that's
when we get a kidnap or
of course, and she dies, and then
Yeah.
so I look the way I analogize this is I call this the guardian angel doctrine. She has a right. She has the right to be in there and be safe, and she has a right to be there. So she's the one that's kind of creating the agency, which is fine in a sense because you don't have the right to tell you can't go into your own home. She has the right to be there, and she's a victim, and that's another thing. It's like we're gonna tell the court, Your Honor, she's on her own. She's on her own. Yeah, this guy strangled her. He's gonna beat her. He has guns, but that's on her. I see it both ways a little bit, but I see it more in the sense that the cops can protect her. That is a valid civil standby, and now that they're inside the house, they probably have lawful access. As I look for this case that I have, John, I want you to chime in here. What do you think about this? This guardian angel.
Yeah, I mean, this is something that I struggle with, right? So I would argue there may be some exigency once you get word on the strangulation, due to physical evidence, right?
Like the fingernails?
Yeah, he's gonna have physical evidence underneath his fingernails and things of that nature. If you don't want to go there, because at the end of the day, every Fourth Amendment analysis is a risk versus reward, right? Every Fourth Amendment analysis is a balancing test. What is the governmental interest versus what is the level of infringement of the individual's rights? We're talking here about making a warrantless, non-consensual entry into the home, the place that has the highest level of Fourth Amendment protection. Weighed against that is where we want to preserve that evidence that may be underneath his fingernails. However, she's already at the hospital getting a full forensic analysis. And so at the end of the day, the evidentiary value of that skin underneath his fingernails, if it's even there, is relatively minimal. And so if you guys want to make the decision where we're not going to go in there and shoot this guy, because we don't want to, it's not worth it to us, then I can't fault you for that.
You don't have to leave. You don't have to leave, John. I mean, you don't have to get all upset about it. He's just asking.
I've had enough, and I'm glad that I wore pants tonight because you stand up, and next thing you know. But yeah, Anthony. I mean, we're talking Ryburn versus Huff, right?
What if you want to?
He rents a room in there, but the common areas are just or her common areas too because it's her house.
No. No, he's a roommate. I mean, look, we can argue that like she's had, it's her house. But we really want to go to federal court and argue that since he's a roommate, he doesn't have the same expectation of privacy as she does in the common areas. Seems to me that they probably have the same. I mean, why not? I mean, that's what we do for roommates. It's he can go and live. Yeah. We don't want to play that game. No, it's let him have the expectation of privacy, but just call exigency. I gave you a case called Clemens versus Couch. And it talks about, you can't do it unless you have exigency, right? So, and I do think that's exigency. I really do. Go ahead.
Sort of as part two of this.
Oh, yeah.
So the next day she calls again, and I was familiar with the call, so I saw a pendant, so I had officers go out there. She's adamant. Now she's really adamant about it. This is my house. I'm going back in with or without you. So now we got an issue.
Yep.
So now we're gonna. Now there's a chance that there's guns in the house, so we have to do a safety sweep. So we get a plan together. We're going to do a call out. In the middle of the call out, whereas we're setting up, suspect comes out, get in his truck. She points him out. There he is. He's leaving in his truck, which we already had identified. He goes around the block. Now we got felony eluding because the lights and sirens follow.
Yep.
He bails, runs into the house, tries to close the garage on us. So we got California line, but now we got a felony, right? So we're good on the probable cause from last night's incident, and the fact that he could be armed. So we get in a foot pursuit, short one. We end up tasing him as he's closing the door on us.
Yep.
Take him into custody. We're good on that. Now we got to do a safety sweep of the house. So because his bedroom door is shut. It's upstairs. We find nobody in there, but his door is closed. Are we still good going in there because there could potentially be something in there?
No way.
Person.
No way. Not in a million years with those facts. Here's the deal. First of all, I do want to clear one thing up. Lang versus California, is it's obviously the seminal issue is misdemeanor pursuit. But I want to be careful with my students in my church of Search and Seizure leaving the church and thinking that, hey, you know what? As long as it's a felony, we can chase him. Because what if that was a bounce check?
Right. Exactly. Yeah.
So look, but that's not what you have here. I am totally good. I am totally good with the chase here. The guy is a violent person. He did a felony eluding under your state law. He's running back in the house. There's firearms in the house. Dude, get him. He needs to be in custody. That's a legit hot pursuit. I am good with it all day long, twice on Sunday, right? But there is no authority to do a protective sweep in that guy's bedroom. There's no reason to believe with those facts that anybody, a physical person, not an inanimate object, you have to have a person who's a danger in that house or in his room, not a inanimate object like a gun.
Gotcha. That clears that up.
And then John did put Weidman versus Huff, which is good on this. Go ahead.
Can you quote or can you put that in? I'm in the other room right now, so that we don't get feedback. But just so I can research that case law, just so I'm clear, because I don't want to make bad case law on this.
Nope, you're good. And then Ryburn versus Huff too. He put that in the chat. That's another. That's an entry into the home for officer safety purposes, and you also have that here as well. Absolutely, the guy. Look, once he comes out the home and you chase him into the home, the rules are a lot better in your favor.
Gotcha. Perfect. You guys are awesome. Thank you.
No, you're awesome.
Appreciate you. Thank you.
You're welcome, brother. And just also, I forgot to ask you, where do I send the bill to? Nick, where is Nick here? Rick, I don't see a Nick. I don't see a Nicholas here. I see a different Nick here. Matthew, okay. You still good for a few more, brother? John?
Me?
Yeah.
And the Washington nightlife I'm missing out on it, but
well, look, actually, I forgot about that. You're on your own time zone. I'm the one it's 10:15 for me. I'm the one that should be, getting ready for my my bedtime here. What's up, Matt?
Hey, not much. You guys can hear me okay?
Yep. And what state are you in?
Illinois.
Okay, cool.
All right. So this is just in reference to I had sent this in the chat earlier in the reasonable suspicion. And so I think this should be pretty easy for you guys, but it came up in discussion on shift. So just with the St. Louis shooting that happened back in March at that doctor's house. So assuming officers effect a knock and talk, the homeowner engages in potential conversation, let the officers maybe step just right inside. It's cold, you're asking to get in, they begrudgingly let you in. They don't want to, but they let you in. So now that we're armed with PC for an offense. Can the officers arrest that individual over their protestation just based on the consent to come in? Or does the consent to come in not equal consent to arrest?
John?
So I just want to make sure, because some of the things that you said gave me pause. He grudgingly let us in, right? So is it
like that? Yeah. Like we do it all the time. Like, hey, it's cold. Do you mind if I step in? This might be your typical shitbag, doesn't like the police, but he lets you in. We don't force our way in. There's no coercion.
Never say, do you mind? Because that's unclear and nebulous and open to many interpretations. You say, can I step in? And they say, yeah, by all means, come on in. I know it's cold out there, right? So we talk about Peyton's firm line, right? When we talk about the burlesque rule, which is plain view seizure. Just because I can see something doesn't mean I have to act. I can grab it if I have to cross constitutionally protected thresholds. There is a constitutionally protected threshold at the entry to the house. Every opening, every door into the home has a red barrier blocking it. You don't pierce that red barrier absent consent, exigency, urgency, emergency, or a warrant. In your situation, I am past that firm line that was established by Peyton, right? I am reasonably inside that house, and so I have access to the subject inside.
That new video up.
Sorry, I was going to queue up the video just to show guys real quick, but
gotcha.
Go ahead, keep going. Sorry, I didn't mean to interrupt.
No, it scared me. But yeah, I mean, you have access to that person if you have PC for them. Anthony might try to argue the validity of consent to enter versus the validity of consent to enter to arrest.
Correct.
I say the subjective intent of the law enforcement officer is irrelevant to the Fourth Amendment analysis.
No, it's not. No, it is irrelevant. But what's relevant is why are you in that house? Did you coerce that guy? Did you overcome his free will by asking him, "Can I get out of the cold?"
Right, and then that is the point that I made. And our questioner, our attendee, said it was valid consent to get in the house.
Yeah.
Yeah.
Yeah. I
I
mean,
agree. That is the concern. Was it actually valid consent? If it's valid consent, you're past Peyton's firm line. You are
well,
inside.
there is the known officer rule, right? The known officer rule says that are you lying about your primary purpose? I mean, I will, and that's a rule that's very hard to, at Blue to Gold, we try to summarize or to analogize these things to make it compatible with understanding because it's tough, right? I mean, there's no one rule that says, this, but the point is, when it comes to an officer rule, you should not be like really bold-faced lying to people about why you want to get into their house. And they're like, oh, you just want to, especially if it creates some kind of exigency or, and they feel kind of compelled to let you in. Does a person feel compelled to let the cops in to get out of the heat or whatever, or the rain?
No.
I don't think so. I don't think so. I mean, the Supreme Court is going to say that's unlawful. You can't tell people you want to get out of the rain. But can I also give you a pro tip? It'd be nice if the cop's like, hey, man, it's really hot out here. Can we come in and talk to you? And go in that house and do what? Talk to the dude for a little bit. And then say, okay, well, cool. Here's the deal. I got PC for you. If the cops said, hey, can I come out and get out of the heat? Come on in, Okay, I don't want you guys out there I don't want you to faint on me, Come on in. And then the first thing the cops do is put handcuffs on him. I got to tell you, a lot of courts are not going to like the way that looks.
Sure. And I guess I was just looking for what the baseline law is like. So what I tell my shift is we always our procedures to talk them out anyway if we can. Like we don't like arresting in the house on knocking talks and stuff like that. But I tell you wanting to know what the baseline is. So yeah, that all makes sense.
I will tell you this. This is some good advice here, okay? And it's worth what you paid for it. When it comes to getting inside the home, be careful. You don't want to coerce these people. You want to be respectful because crossing that threshold is going to be they're going to criticize you. Like, hey, were you legit? But getting that person out of the home is way easier. Say, yeah, can we talk to you about something out here? You want a prize. The famous one was the FBI with the prize. Remember that one with the 70s where they called up like 200 people or something that were wanted? I think these guys a lot had warrants, but the point is it could have worked with warrantless searches too. But they called all these people and said, "You want a TV?" and come down and collect it. And they all came down at one time and they did this whole it was all like hidden camera and they wrapped them all up. And it's like that's a great example of getting people out of their house. So getting inside the house, be careful. Getting outside is fine. Is Nick still here? Nick had a question. The Nick that had a question, if you're still here. Yeah, baseball tickets. That's cool. We'll do one more question. Thanks, Matt. You're awesome. Matt, you're on deck.
Good evening.
Good evening.
So kind of building off of, I believe it was Frederick's question. Officers, roommate situation, family violence, strangulation. Had the officers already been present inside the house? Initial response, they come inside, they start speaking with her.
Yep.
Him being I guess, tenant renting a room. If
Yep.
she didn't have any common authority over that room, if she never is allowed to enter that room,
Yep.
does he get a new threshold where you
Great
can't
question.
enter?
A great question, John. You know what we're talking about here? Have you heard this question before?
I have. And so we're inside the home, but now he has like his own separate little home inside the home.
And
Yep.
I kind of wanted to ask the question both ways, whether or not it's literally just a room. He literally just rents a room, or kind of your semi-divided, still connected mother-in-law suite. Maybe you share the washer and dryer, but they can physically deadbolt that door or something like that.
It's a tough one. That's a tough one. I'd probably I would probably my advice is to not do it unless you have exigency, because I do think he has a higher level of privacy in that particular room. But look, a lot of these questions, Matt, come up when it's the husband and wife, and the husband barricades himself into the marital bedroom, and right. But
I've never seen anything like this. I've never had a legit tenancy inside of a residence that I'm aware of.
Yeah, those are tough. Like I think first of all, again, it's debatable. But she doesn't. I mean, if you're going to enter that room, right? And you're going to say, how do I get in here? Like, what brings me into this room? I just don't know. Being qualified immunity purposes aside, I don't see how just being in the house is enough. I mean, that is a clearly delineated, protected area as to him, and it's not part. It might. Is it really part of the house? Is it really? That's the part. Like when it comes to look, Matt. Most of the questions come with the husband that he batters the wife, right? The cops are inside lawfully, consent, whatever, right?
Yep.
He's in that back bedroom, and the cops want to make a forced entry. I'm very clear on this that I think we're good to go
Yep.
because there is no extra constitutional entry into that back bedroom. Does that make sense?
Yeah, I agree.
But his room, I think we do have an extra constitutional entry. John, am I wrong on this?
I struggle with it because I
Yeah.
mean, you know, right? You know as well as I do, officers struggle with threshold arrests.
Yeah.
Every time we teach Brizuela, no matter where it is in the country, despite the fact that the Ninth Circuit said it's clearly established, they should have known, they should have left as soon as they did. Every time we teach Brizuela, officers across the country are like, "Whoa, wait, you have to leave, right? If
Yeah.
you get off my colonel, no, I got
Yeah.
PhD for a felony for this dude. I'm not walking off, right? Yeah, okay."
Yeah.
And so the threshold arrest concept is difficult for officers to grasp.
For
You're
sure.
telling me there's some kind of an invisible barrier between him and me? That's hard to wrap your mind around. And I think that it is unrealistic for us to say you are inside this home and now this empty, this hollow core door between
Hmm.
you and this guy is some other kind of additional constitutional protection. No.
Yeah. So you would say no, we can do it.
I would say no, you can do it, but do I absolutely understand the alternative argument? Yes. But I
Yeah.
also think that we have to live in the real world, and I think the Supreme Court
Yeah.
would uphold the action.
You're
Yeah.
probably asking the wrong questions if you're worried about common authority once you're already lawfully present inside of a house.
Well, they don't have common authority. That's one. I mean, we know that the roommate, the victim, does not have common authority over the suspect's room.
Unless she does. Does she do his laundry sometimes? I'd argue
Well,
maybe.
no, no. Look, if we have that, Matt, then you made it a lot easier case. We are talking about a roommate that truly does not share their room with the other roommates. That's going to be the tough case. But I think that John is on to something here because if the Supreme Court says that no, if they're in that room, they're kind of like safe, even though you're in the house, right? God, that's a tough one, man. That's a big ask. That's a huge ask of these officers. I think, look, I think if you're in the house, generally speaking, the rule probably should be that you can grab him if you're in the house lawfully.
I like
But
it.
it's going to be that OIS that occurs in his bedroom. Now we're going to go to the mat. The good thing is you're going to get qualified immunity. I mean, I hate selling cases on qualified immunity because it's a cop out, right, Matt? It's like, well, I don't know. Maybe since it's not clearly established, I guess we're going to win. I don't want to win cases on qualified immunity. I want to win them on this like summary judgment, like, hey, the court says you did right. You're good. If that happened tomorrow, I'll do it again. That's how I want to win cases. With this one, it could be a little tough one, but I think John's right. Overall, I think he's right.
Awesome. Well, I greatly appreciate it. Thank you guys. I'm glad I'm asking hard questions.
Yeah, good. But don't put us in your lawsuit.
I was gonna
Yes,
say,
sir.
this is legal education, not legal advice.
That's awesome. All right, guys. Well, look, I think we did an hour and a half of the Search and Seizure show. I could not have done this without my good friend and senior legal instructor, John. John, I can't thank you enough for being here. I wasn't sure you're going to show up. That's why I didn't want to bother you while you're traveling, but I appreciate you.
It's my pleasure, Anthony. I appreciate the opportunity. A lot of good questions tonight. A lot of good opportunity to think through situations.
Yeah, we had a lot of great questions. Okay, it's my bedtime. Get ready for my class tomorrow. John, you enjoy Washington. I will enjoy Texas. You know who's going to have more fun. No, maybe not, man. These Washingtonians, they love you, man. The feedback is like, oh my God, they want to put you on the chariot. We love John. We love John.
Anthony, I want to make a plug, man, real quick if I
Oh,
can,
please.
for my Washington folks, right? Guys, this week we are in like Pasco, right? We've been to Richland before. We've been on the west coast of Washington a lot. These officers, I don't know if anybody joined us tonight, but their minds are blown by what we're talking about with these Washington specific cases, right? So if you guys have us out to your state, if you are one of those outlier states that are not in keeping with the federal standard. We're talking Washington, we're talking New York, New Jersey, New Mexico, Delaware, Pennsylvania, Alaska, Hawaii, and God bless them, those officers in Oregon.
Yep.
You need to have us out, man, because we are not teaching in those states to the national standard. We are teaching state specific cases.
Yep.
And you can't, as a Washington law enforcement officer, as a New Mexico law enforcement officer, you can't take this national training, right? Desert Snow, God bless them. I love them, right? They're doing good stuff out there. But if I'm a law enforcement officer in the state of Washington, I can't take a national standard. It's not going to help me. It's going to set me up for failure. It's going to do more harm than good because it's not Washington specific. Just because the United States Supreme Court said something doesn't mean I can do it in Washington. So if you are one of those outlier states, right? If you are a law enforcement officer in one of those outlier states, please have us out, attend our class, state specific, and you set yourself up for success. And we will do what we can to help you get it right every time, specifically in your state.
Yep. And just go to bluetogold.com. If you actually go to the homepage, you'll actually see a interactive map of everywhere we are. Case law for Cosme, simple and clear. Let's watch for it. Boom. So we are in a lot of places, right? So, we have classes near everybody, right?
And if we don't, host us, have us out to your agency.
Except New York. We don't want anything to do with New York. I'm joking. We have classes there too. All right. Hey, look, Noah, if do you want to host us in West Virginia? Or do you know a host in West Virginia? Look, we love going to West Virginia. We've actually been there many, many times. So host us or help us with a host. Training@bluetogold.com. All right. For those who are watching on demand, who are watching on YouTube, we appreciate your time as well. An hour and a half is usually a little longer than we go for, but this was off the hook with the questions and so forth. Thank you so much, guys. Again, thank you, John. And with that, we are out.